better today. Our story begins in March 2025. Glow Labs in Rapper Height, a rising local skincare brand, is searching for the perfect influencer to promote their newest product, the Glow Lab Radiance Serum. They reached out to Alicia, a popular lifestyle influencer with over 500,000 Instagram followers. Today, they meet to sign a contract.
Welcome, Alicia. I'm so glad you agreed to work with us. Our Radiant Serum has just launched, and we truly believe your platform is the perfect fit our brand.
Thank you. I love supporting local brands. I tried a sample of your serum and I really like it. I think my audience will connect with it.
Wonderful. Let me walk you through our contract. The terms are simple. You will post 3 Instagram videos featuring our Radiant Serum within 2 weeks. In return, Glow Lab will pay you 20,000 ringgit. However, payment will only be released after all the posts are completed. Do you agree to these terms?
3 posts in 2 weeks. This is very manageable. And earning 20,000 is far from my range. I agree.
A legally binding contract has now been formed between Glow Lab and Alicia under Section 10 of the Contract Act 1915. A contract is valid when there is offer, acceptance, consideration, capacity, and intention to be legally bound, all of which are present here. Glow Lab offer of RM20,000 was accepted by Alicia in exchange for the 3 promotional posts. The contract is clear and both parties understand their obligation. Alicia gets to work immediately. She filmed her first Instagram video in fun, creative, and convincing. She applies the serum on camera and shares her honest first impression. The video is posted, and within the 48 hours, it explodes online.
1 million views. Our website has crashed from the traffic. Sales have tripled overnight. This is unbelievable. I cannot wait to see what her next 2 videos will do.
Glow Lab is thrilled. One single post by Alicia generated 1 million views and dramatically boosted their sales. But behind the scenes, something has gone wrong. Days after posting her first video, Alicia noticed her skin has become red, swollen, and painful. Then she visited a doctor immediately.
Miss Alicia, based on my examination, you have developed contact dermatitis or a skin allergy reaction. The inflammable is localized to your face, which is consistent with a topical product applied to the area recently. I strongly advise you to stop using the product immediately. Continuing to use it could cause a more severe reaction. I will issue you to a medical certificate.
So, the serum caused that?
Based on the timing and location of the reaction, the serum is the most probable cause. I cannot rule out all other factors with absolute certainty, but this is my professional medical opinion.
For you of something serious. After using your serum to film my first post, I experienced a severe allergic skin reaction. My doctor has issued me medical certificate. I cannot continue using your product to film the remaining 2 videos. I'm unable to complete the contract.
Oh, Alicia, I'm sorry to hear that, but the contract is very clear. You must complete all 3 posts before we release any payment. If you refuse to continue, we will not pay you anything, and we may take legal action for breach of contract.
I have a certified medical document. I physically cannot apply that product to my face again without risking serious harm. You cannot hold me a contract that requires me to hurt myself.
The dispute escalated quickly. Alicia filed a lawsuit against Glow Lab, claiming RM20,000 for her services. Then Glowlab filed a countersuit, claiming Alicia breached the contract by refusing to complete the remaining 2 posts. The matter goes to court. The case is now before the court. Both sides have engaged lawyers to argue the position.
Order in court. This matter concerns a contractual dispute between Ms. Alicia Tanwilling and also Glowlab Setia Berhad. The plaintiff seeks compensation arising from partial performance of an influencer agreement, while the defendant alleges breach of contract. Counsel for the plaintiff, you may proceed with your opening statement.
Thank you, Your Honor. My client Alicia entered this contract in complete good faith. She performed her first obligation and performed it exceptionally well. 1 million fuels, triple sales. Glowlab benefited enormously. However, the very product she was contracted to promote caused her a medically certified allergic reaction, which making future performance not just difficult but medically dangerous. On Section 57 of Contract Act 1950, where performance becomes impossible through no fault of the producer, the contract may be frustrated. Furthermore, on Section 66, Glowlab cannot return the benefits of Alicia's performance without compensating her. We ask the court to award Alicia fair and just compensation.
Thank you, counsel. Counsel for defendant, you can start.
Your Honor, with the greatest respect, frustration is a very high legal threshold that has not been met here. The contract was explicit. 3 posts, then payment. Alicia completed only 1 out of 3. Under Section 40 of the Contract Act 1950, her refusal to complete the remaining posts constitutes a clear breach. Glowlab was denied the full promotional value is contracted for. The defendant seeks damage for losses arising from Alicia's failure to perform.
Dr. Rashida, you examined my client after she wrote last product. Please tell court your findings.
I found that Alicia had developed contact dermatitis or a skin allergy reaction on her face. Based on the timing and the location of the inflammation, the most probable cause is the topical skincare product she applied shortly before. I advised her to stop using the product immediately to prevent further harm.
So, in your professional opinion, would it be medically safe for Alicia to continue applying this product to her face?
No, continuing to use the product could trigger a more severe reaction. I would not recommend it.
Dr. Rashida, can you say with absolute certainty that the Glowlab serum and not some other product caused this reason?
I cannot rule out all other causes with absolute certainty. However, based on the clinical evidence and timing, the serum remains the most probable cause.
So, it is medically possible that something else caused it.
It is possible, but unlikely.
Your Honor, the medical evidence is inconclusive. Furthermore, the Contract Act requires Alicia to post videos. It did not specify that she must personally apply the product in every post. She could have promoted the product creatively without applying it. Her failure to explore alternatives constitutes a breach under Section 40. Under Section 51, a promisor must perform their obligation fully and exactly as agreed. 1 post out of 3 is not full performance and does not entitle Alicia to any payment.
Your Honor, a skincare influencer promoting a product she has not personally tested would be misleading to the audience. That is commercially unreasonable. More importantly, the fact is that Glow Lab has already received a massive benefit. 1 million views, triple sales, and significant brand exposure, all from Alicia's one post. To allow Glow Lab to return those profits while paying Alicia nothing is unjust enrichment. Under Section 66 of the Contracts Act 1950, where a party has received benefits under an agreement, they are bound to restore that benefit or concede the other party. Justice demands that Alicia be paid for the failure for her delivery.
After hearing all arguments and examining the evidence, the judge is ready to deliver her ruling. This is the moment that will determine the legal outcome for both parties.
Having considered the submission of the both parties, the documentary evidence before this court, and the testimony of the medical witness, the court is now prepared to deliver its decision. The existence of a valid contract is not disputed. Under Section 10 of the Contract Act 1950, all essential elements of the contract formation are clearly present, namely offer, acceptance, consideration, capacity, and intention to create legal relation. The court further finds that Alicia failed to complete all 3 promotional posts required under the agreement. Accordingly, her refusal to continue performance constitutes a breach under Section 40 of the Contract Act 1950. On the issue of the frustration under Section 57, this court accepts that the plaintiff suffered a genuine medical reaction. However, the doctrine of frustration applies only where contractual performance becomes legally or physically impossible. The threshold is high. So on the present facts, that threshold has not been fully satisfied. Nevertheless, this court cannot ignore one undeniable fact. Glow Lab obtained substantial commercial benefits from the plaintiff's partial performance. The first promotional post achieved over 1 million views and significantly increased the defendant's sales and public exposure. To permit the defendant to retain those benefits while paying nothing was overruled, in the opinion of this court, be unjust. Accordingly, pursuant to Section 66 of the Contract Act 1950, the defendant is ordered to pay the plaintiff reasonable compensation in a sum of 7,000 ringgit Malaysia. The plaintiff claim for the full 20,000 ringgit Malaysia is dismissed. The defendant counterclaim is likewise dismissed, and each party shall bear its own legal costs. The court is urgent.
So, what can we learn from this case? A contract is a legally binding promise. If you breach it, even for a junior reason, there are legal consequences. But the law is also fair. It will not allow one party to benefit from another's effort without paying for that benefit. The key legal principles applied in this case are Section 10 on valid contract formation, Section 40 on breach of contract, Section 51 on the requirement of full performance, Section 57 on frustration, and Section 66 on compensation for benefit received. That's all. Thank you for watching.